Hello and welcome to the webinar today regarding establishing Nexus in asylum cases after matter of AB. My name is Ashley Hebner. I'm with the National Immigrant Justice Center, and I'm here with some colleagues from Harvard's Immigration and Refugee Clinical Program. Before we get started, a few housekeeping matters. This webinar is being recorded, and assuming that everything goes smoothly on the technology side, the recording will be up on NIJC's website probably early next week. So if you have to cut out early today or wish to recommend the webinar to someone else, you can access it on our website. In addition, throughout the webinar today, all attendees are in listen-only mode. So if you do have a question, and we welcome questions throughout, don't hesitate to type the question in the box on your GoToWebinar screen there, and we will answer some questions as we go along, and we'll also have a question and answer period towards the end as well. So without further ado, a brief intro to NIJC and then an intro to Harvard. For those of you who are not familiar with NIJC and our asylum work, NIJC represents more than 600 asylum seekers each year in all areas of asylum law. So we represent detained immigrants, non-detained immigrants, families, children, and we're very active in impact litigation across the United States on asylum-related issues, and specifically have participated in a number of the significant Board of Immigration Appeals cases on asylum issues that have come out recently, such as matter of AB, which we'll talk about today. We utilize a lot of the information that we gain from our asylum-seeking clients to advocate with and provide intel to members of Congress to really push forward improvements to the asylum system. And so all of that information that we've been able to utilize through our representation of asylum seekers will be part of the webinar today, and we'll be referring to prior cases and hopefully helping you all as you move forward in your cases with your asylum clients.
So this is Debbie Anker. I'm co-founder and director of the clinic at Harvard, the clinical program at Harvard. So we are also engaged in a lot of direct representation of individuals applying for asylum and other forms of humanitarian relief and protection. We work obviously through our students who do a lot of the representation in collaboration with us. We have a partnership with Greater Boston Legal Services, which is the largest provider of legal services in New England. We engage in appellate litigation. We participated as amicus in some cutting-edge asylum cases, including matter of AB, ARCG, where we represented the American Immigration Lawyers Association, NGUSI, among others. We've set some important precedents, especially in the First Circuit, around children asylum seekers. We're also known for our groundbreaking work in the field of gender asylum, which goes back about 20 years.
So this webinar today is intended to a large extent for attorneys who have some prior asylum experience. Hopefully you've represented asylum seekers before, you've attended or participated in NIJC's representing asylum seekers training in the past. So we're not going to spend much time talking about asylum more generally, or even the matter of AB decision more broadly. We're going to focus today very specifically on the Nexus element. So if you have questions regarding asylum more broadly or the AB decision more broadly, we'd encourage you to check out NIJC's materials or other materials online related to asylum representation and the AB decision. We are going to spend a little time, though, briefly going through some asylum backgrounds to get everybody on the same page as to what we're talking about today. We'll talk a little bit about what exactly Nexus is, what we mean when we say the word Nexus, a little bit about the matter of AB decision, and then we're going to jump right into some case examples, because we know for most of you, really talking through some hypotheticals and case examples is usually the most helpful part as you think through how to prepare your own asylum cases. So really quickly on some asylum background information. So both Debbie and I are going to talk through the asylum elements today, and these can be sort of split into about 5 or 6 different elements depending on how you're going to look at them. I'm going to talk about 5 different elements that you typically need to establish in order to prove your eligibility for asylum. So you have to show that you have a well-founded fear, has to be of persecution. The persecution has to be perpetrated by the government or an entity the government cannot or will not control, is unable or unwilling to control. has to be on account of one of these 5 protected grounds. So that on account of part, that element number 4, that is the nexus element, and that's what we're going to be focusing on today. One thing we're also going to be emphasizing today, as we do in many of our asylum trainings, is the importance of keeping each of these elements separate. Very frequently, unfortunately, in a lot of the decisions coming out of the Board of Immigration Appeals or from the Attorney General, especially regarding claims involving membership in a particular social group, we see a lot of conflation between the protected ground and the on account of element. And so in order to get a proper analysis and that does not harm the asylum seeker, it's very critical to keep these elements separate. And one of the best things you as the attorney can do to ensure the adjudicator keeps the elements separate is to be sure that you are keeping those elements separate in your own analysis, in your briefing, and in your arguments in court. So another thing that's really important to keep in mind is that, the matter of AB decision, as well as a few Board of Immigration Appeals decisions that have come out recently, very clearly imply that they are intended to limit the ability of certain categories of asylum seekers from getting protection across the rules. So to create a blanket rule to prevent certain categories of asylum seekers from getting protection. And so despite the implications of those decisions, it's important to remember and to emphasize to adjudicators that case law has consistently reaffirmed that asylum matters require a case-by-case analysis, that each element in the asylum test that we just talked about require a case-by-case analysis. So even if an adjudicator at the Board of Immigration Appeals, the Attorney General, has said in one decision that this particular social group is not viable, or that in this particular case there is no nexus between the persecution and the protected ground, that does not mean that all cases with similar facts are going to fail. The adjudicator must conduct a case-by-case analysis, and it's really critical to constantly remind the adjudicator of that fact. So this slide here, the asylum system, is just intended to provide a quick refresher as to what it means that the matter of AB decision was at the Attorney General's level, right? So most of the time when we're looking at published decisions in the immigration court system, they're coming from the Board of Immigration Appeals. But the Attorney General does have the ability to certify certain cases to him or her, and then issue a precedential decision as a result of that certification. We're not going to spend much time talking about this as it relates to matter of AB, but it is important to keep in mind that the process by which the Attorney General certified the case to himself in AB was unusual, and there are many concerns from advocates as to how that decision came to him and the process by which the certification occurred in the first place. So for more information about that, you can see NIJC's practice advisory on matter of AB. You can read some information about it in the AB decision itself. But something to keep in mind that there were many problems with the AB decision, and one of those problems was the Attorney General certification itself. And then finally, getting back to the point of how the matter of AB decision has been portrayed. So in the media, this decision has really been presented as sort of the end of asylum for gang or domestic violence-based asylum. Many adjudicators seemingly have jumped on that as well. It's important to understand what the AB decision says, but it's also important to understand how that decision fits in with other courts of appeals case law that may exist in the jurisdiction where you practice. So we'll talk more about exactly what the AB decision says in a bit, but it's important to keep in mind that, the AB decision did not overrule any Court of Appeals case law. It specifically overruled some prior board case law, but it did not touch on Court of Appeals case law. And so you need to look very carefully at the Court of Appeals case law where you practice and find the nuances and the differences between what may have been asserted in matter of AB or other Board of Immigration Appeals decisions, and what is good law in your circuit. So for example, here in the Seventh Circuit, there's very good case law talking about what constitutes a particular social group, talking about how you can prove nexus when the harm is by a non-governmental actor, and talking about what it means when the government is unable or unwilling to control the persecutor. And that is all still good law. So, unless you have the Attorney General or the Board of Immigration Appeals explicitly overruling Court of Appeals case law, or you have the Court of Appeals deferring to the board or the Attorney General under Chevron, that Court of Appeals case law is still good. So it's important to know what's coming out of the board and the Attorney General's office when it comes to precedential case law, but it's just as important to understand how the Court of Appeals case law in your jurisdiction fits and what you can make use of to distinguish for your case and to distinguish between the decisions coming out of the board and from the Attorney General. And I'm going to now turn it over to Harvard for a quick discussion of Nexus.
So this is Debbie Anker. I just want to emphasize a point that Ashley made, the importance of parsing the definition. And we have a slightly different way of looking at persecution and failure of state protection as all serious harm and failure of state protection is part of persecution, but it's basically the same message. These are all different different elements. They raise different legal questions. It's also important to have a background conception of what refugee law is about, why we have refugee protection. Refugee law exists to provide substitute protection when a person cannot rely on his or her home country, when he or she cannot return to his or home country for a specified discriminatory reason. That's one of the 5 grounds. So the purpose of refugee law is humanitarian, to provide protection, not to punish bad states. So when you have a very aggressive effort by the board or DHS to identify the intentionality of the bad actor, you should push back as much as possible. So the for reasons of or on account of language, referred to as nexus, connects the persecution and one or more of the 5 grounds. And that's nexus is obviously the element that we're looking at today. So nexus is widely understood as a causal, non-coincidental link between the persecution suffered or feared and the particular ground of protection or protected status or belief, race, religion, nationality, political opinion, or membership in a particular social group. We're ready for the next slide. So these are different models for understanding this causal nexus element. So the first question, does the ground have to be the exclusive reason? No, then the answer is no. And I would refer people to it's an older board decision, matter of SP. It's a 21 INN decision 486. It's a 1996 decision. In that case, the board found that the past persecution and well-founded fear. It found past persecution, well-founded fear, where the Sri Lankan authorities believed that the applicant was a political opponent. They had raided a Tamil camp where SP was a prisoner. They interrogated him. They thought he was a Tamil tiger, that he had views against the government, and also that he knew about the identity of Tamils and the locations of their camps. So there were different reasons for infliction of the harm, to punish political opponents and to get information about others in the rebel group. And the board held that various motives are okay as long as there's a nexus to show at least one reason was a statutory ground. The but-for cause in tort law, we'll get to this in the next slide, but I think a simple but-for reason is probably not good enough after Real ID, but I don't think it poses a major problem. Also, is it reasons versus motives? I think I would emphasize the word reasons, and we have the word reason now with the Real ID Act, and I think that's very important. Subjective intent. Sorry, I forgot to mention that. No, there's no. This is not an inquiry into subjective intent. Does it matter whether there's a punitive intent on the part of the persecutor? For example, in the Kasinga decision, the very classic Kasinga decision of the board, whether FGM was inflicted to punish or cause harm or just performed as part of a cultural tradition, the board said no. The asylum applicant did not have to prove subjective intent or malevolent subjective intent or an exclusively persecutory motive. Rather, you can look at the societal purposes of persecution. In Kasinga, the board found that FGM was sexual oppression, according to expert evidence, even though people performing it thought it was beneficial to the applicant. It was done by women in the village who thought it would help her assimilate or become part of the tribe. That did not matter. And mixed motives, yes, the convention ground need not be the sole or even dominant motive for the risk of persecution. It needs to be a central reason, not the only reason. And that's very clear throughout all of the case law, and it's very clear from the Real ID Act, which we'll go to next in the next slide. So the Real ID Act, this was a modification to the asylum provision of the Act in the burden of proof. So the burden of proof is on the applicant to establish that he's a refugee, he or she is a refugee, and must establish that one of the 5 grounds was or will be at least one central reason for persecuting the applicant. And we'll go to the next slide. The case of matter of JBN and SM, this was the board's first decision, and really it remains the major interpretation of the provision on Nexus by the board. And the board held in that case that the protected ground cannot play a minor role, it can't be incidental, tangential, superficial, or subordinate to another reason for the harm. Rather, it must be a central reason for persecuting the respondent. That case, this is very important, that case then got appealed to the Third Circuit in the Nadeshimye, excuse my pronunciation, versus Attorney General. You have the site up there. And although the court upheld the board's decision that Nexus was not established in that case, it clearly said that the board's use of the word dominant in that in the formula that you see above, that use of the word dominant is wrong. Congress's use of the phrase one central reason rather than the central reason was deliberate. The legislative history clearly showed that. This mixed reasons test should not depend on a hierarchy of central motivations. It could be one among many. However, it cannot be just a reason. It must be a central reason. Withholding, is withholding different? Is the standard in withholding different? Remember, the Real ID modified the asylum statute, not the withholding provision. And is there significance to that lack of reason? And the Ninth Circuit has said, yes, there is significance to that, so it could be a kind of but-for cause when you're looking at withholding, but the board and every other circuit that's looked at it has disagreed with the Ninth. I think it's really important, the recognition of the mixed reasons or motives test. What I find very frustrating is in many subsequent cases, the board pays lip service to the mixed motive reasons test. It always says it's applying it, but it very, very often does not apply it, and instead implies an exclusive motives test, in fact. But the law is clear on mixed motives, so you really have to come back to that over and over again. At the IJ level, remind the adjudicator that, you know, this is a mixed motives test, and that's clearly what what Congress intended with Real ID. Before the board, the same, make the same point. The circuit courts show how the board and the IJ, even though they say they're applying the mixed motive test, is not in fact applying a mixed motives or reasons test. This is now Tabby Ardalan, our assistant director here, and on the next part. Yeah.
So just to remind folks of something Ashley mentioned at the outset, it's important to remember what Nexus isn't and not to conflate Nexus with the protected grounds, in particular with membership in a particular social group. So the board in matter of LEA made clear that an asylum applicant need only prove that he or she is a member of a certain person's family, not that that person was in fact targeted on account of a protected ground. The challenge with LEA is that the board, I think, mistakenly held that the respondent in that case couldn't establish Nexus, and found that the respondent was targeted because the gang members wanted to avoid criminal prosecution, not because the gang members targeted her as a member of her husband's family. And so particularly in family social group cases, it's important to develop in the record animus against the family as a whole. And there's really helpful cases, particularly out of the Fourth Circuit on membership in family social groups that are helpful to look at to see what the court pointed to in terms of demonstrating that the petitioner was targeted because of her relationship to a family member. In Hernandez-Avalos, it was the relationship to her son. Next slide. So it's well established in Nexus that the burden of proof in terms of Nexus can be carried by showing either direct or circumstantial evidence of Nexus. From Supreme Court decisions to Board of Immigration Appeals decisions, this has been reiterated multiple times. And oftentimes, when you're developing your cases, you will be pointing to mostly circumstantial evidence of Nexus, including how other people in the population are being treated and how they face similar circumstances. And it's important to draw in as many different kinds of evidence of Nexus as possible, because there is a totality of the circumstances approach. So as many different pieces of circumstantial and direct evidence as possible. Next slide. In terms of direct evidence, the best things to point to are often statement or actions by the persecutor. And that may come out generally through your client's own testimony or supporting affidavits that your client can obtain from friends or family members or other people who witnessed or heard statements or actions by the persecutor that demonstrate the persecutor's reasons for going after your client. Additionally, sometimes you may be lucky and have a threat letter or a direct statement by the persecutor, him or herself. But if not, it can come out through other evidence. Similarly, statements or actions by asylum seekers themselves can help demonstrate Nexus. So for example, statements or actions expressing opinions against gang members or feminist opinions, standing up to persecutors. And those two can come out through the client's own affidavits as well as through supporting affidavits. Beyond direct evidence of Nexus, there's circumstantial evidence. So persecutors' treatment of similarly situated people, the state's failure to protect similarly situated people, and suppression or prosecution of certain groups or opinions. Next slide. And in terms of circumstantial evidence, country conditions is particularly important to demonstrate. So to the extent that you can find country condition reports from the State Department to NGOs, to news articles, or expert affidavits that document that what the client says is in fact happening in that country is actually happening, and that can show the society's views about the applicant's protected grounds, immutable characteristics, and why the client might be singled out or persecuted for those reasons. And oftentimes there are really helpful country condition experts who are really helpful in not only providing sort of the general context, but also tying that general context to the specific facts of your client's cases. And this is especially important in the context of gender and gang-based claims.
All right, so we are going to do a very quick overview of matter of AB. As I mentioned, we have another webinar that talks more in depth about the AB decision, but really briefly, just so we're all on the same page about what we're talking about here. So matter of AB, the actual holding of the decision is quite narrow. So all it did was overrule a prior decision called matter of ARCG on procedural grounds. ARCG was a decision recognizing a particular social group of married Guatemalan women in relationships they are unable to leave in the context of a domestic violence-based claim. And the Attorney General overruled that decision, finding that it was the product of DHS concessions as opposed to a proper and thorough legal analysis. And specifically, the Attorney General said that in ARCG, the legal analysis of two of the requirements for establishing particular social group in most circuits, the social distinction and particularity requirements, were not proper, and that the nexus analysis was insufficient as well. But ultimately, that was the reason for overturning ARCG. It was overturned on procedural grounds, and then the Attorney General went on and overturned and remanded AB's decision herself, finding that the board's analysis in AB was improper as well. But very, very narrow decision overall. However, there is substantial significant dicta. I mean, most of the decision itself is simply dicta. That's very, very negative. And so the concern for most advocates is that while the holding in the decision itself is quite narrow, that judges are going to jump on all of these negative statements, all of this dicta, and treat them as if they are binding law and rely on them to deny cases moving forward. And of course, this is what we've seen, particularly in the media, and the way the media has portrayed the AB decision as eliminating asylum for gang and domestic violence-based claims, which of course is not accurate. But when you look at the dicta in this decision, it's very, very harmful. So, for example, the Attorney General says that generally these types of claims, these domestic violence and gang-based claims, will not be viable, that they'll only be viable in exceptional circumstances. And of course, there is no exceptional circumstances standard for establishing asylum eligibility. The Attorney General throws around a number of different formulations for what it means to show that the government is unable or unwilling to control a non-state persecutor, while again never overruling or vacating any prior standards that were set out to meet that element. The Attorney General asserts that gender-based particular social groups, specifically when they are based on a relationship that cannot be left, are impermissibly circular, and then also urges adjudicators to consider denying asylum on a discretionary basis based on the way someone may come to the United States, based on statements they may make at the border, or based on the fact that they traveled through other countries before coming to the United States but did not seek asylum there. So for our focus, in terms of nexus, the AB decision did a few things. So first, the Attorney General simply restates the one central reason standard. And so at its base, the AB decision does not change anything as to nexus. The Attorney General reasserts, as he must, that the one central reason standard is what governs establishing nexus in an asylum case. And so that's nothing new. There's no new case law created, no new legal standard created for nexus as a result of the AB decision. But then he goes on to imply again in dicta, to state in dicta, that when the persecutor has a personal relationship with the victim, so for example, in a domestic violence or family violence-based claim, or perhaps in the case where there is some personal interaction between a gang member and the target of the gang, and that relationship is what is perceived as turning into the persecution. The Attorney General says it will be difficult for the claim to succeed without much of an explanation beyond that. So again, that's dicta. There's not much explanation for that statement. There are no legal citations for that statement, but it is there. The Attorney General also says that it's going to be hard to prove nexus when the persecutor is not aware of the alleged group's existence. And this goes to the idea that if you have a group that is not a particular social group, that is not a visible group in the sense of, formal membership and a membership roster and things that can be understood by the public very clearly, that it's going to be difficult to establish nexus. And that seems to create a standard in the nexus analysis that does not quite exist. The connection between the persecution and the protected ground is just a characteristic. You have to prove that the characteristic that forms the basis of the particular social group is what gave rise to the persecution. You don't have to show that the persecutor understood a group as existing with the specific language in which it was defined in the asylum case. But that seems to be what the Attorney General is implying here. And then probably most significantly, the Attorney General provides 2 examples of claims where he says it may not be possible to establish nexus. And I think this is where the ignoring of the mixed motive standard really comes into play. So he first gives the example of a gang may target somebody because they have money or property, or because they'd like to inflict violence on the community. And the Attorney General says in that case, there would not be any nexus. But of course, this ignores the fact that persecutors, gang members, typically have multiple reasons that they may target somebody. And just because they may choose to target somebody because they have money, or they may be able to get money for them, does not mean that there's not another protected ground at issue there. In the Seventh Circuit, we have a really good case called Orejuela, in which, from a number of years ago, involving a wealthy land-owning family in Colombia, in which the Seventh Circuit said that, the FARC guerrilla group in Colombia would probably love to go after anyone in the country to get money from them, but they have chosen specifically to go after this particular group of this land-owning cattle farmers in Colombia for a very specific reason. And the evidence showing that they like to go after that particular group for that particular reason is enough to establish nexus, even though they may have other reasons in addition to that for going after that group and for going after other groups. So the AB decision really ignores that idea of mixed motives. They also say that an abuser may target his spouse because of the pre-existing relationship with her, citing back to a decision in 1975, which I think is particularly concerning because obviously our understanding as to how and why domestic violence occurs has changed dramatically and evolved quite a bit since 1975. Gender violence is now very much understood as a method of power and control, as opposed to something that is coming out of a personal relationship or the result of substance abuse or something like that. So the fact that the Attorney General cites to a 1975 decision for this point, I think is particularly troubling. But again, it still ignores this idea of mixed motives, that yes, the abuser may be abusing that individual because of their relationship, but that does not mean that there is not a protected ground that is giving rise to the persecution as well. So that's the AB decision in terms of how it talks about nexus. And again, if you want more information about the decision or how it impacts other parts of the asylum claim, you can check out our webinar specifically on that. But at this point, we are going to jump right into some case examples because, again, we think this is the most important part of trying to walk through these claims and trying to think about, in your own cases, how can you establish nexus? So the focus here is really going to be on Central American cases because those are the cases that we think are, most likely to be affected most by the AB decision. That's clearly what AB was intended to target. And those are the cases that we see right now as being the most challenging as a result of matter of AB. So again, there will be a Q&A at the end, time for a Q&A, but please don't hesitate to type in questions as we go along, and we can answer them as we go through. So the first 2 case examples we're going to talk about here are common scenarios involving gang recruitment and extortion. So when we see gang-based claims, there are typically a number of different formulations that we see, and 2 of the most common are recruitment-based and extortion-based. So just reading through these 2 examples, the first example involves an individual who was being forcibly recruited by the Mara Salvatrucha. He, tried to ignore them. He tried to put off having to say no. He did not want to join them. They became more aggressive until ultimately they physically harmed him and they had weapons. They threatened him. They gave him a deadline, essentially, by which he had to join them. And then he fled to the United States before they could reach that deadline. So that's a common fact pattern that we see, especially among individuals who come here when they are young, teenage boys, sometimes teenage girls, who are coming to the United States, sometimes as unaccompanied children. The second example is another common one we see in the gang context. So this is extortion. So in this particular case, you have a woman who owned a small store. It was operating out of her home. And as frequently happens, the Mara 18 gang began charging her a tax, that she could not operate her store unless she paid this tax. Eventually, she was not able to pay the tax anymore, and she told them that if she couldn't pay the tax, she didn't have the money, and they told her that that was not acceptable, that she had no choice, she still had to pay. So she closed her store, hoping that if she closed the store and it was clear she could not pay the tax because she didn't have her store anymore, that would be enough. But it wasn't, and the Mara 18 members continued coming to her home and threatening to harm her and threatening to harm her family if she did not pay them. And so she ended up fleeing to the United States with her 2 children. So when we start to think through how do we establish the connection between the persecution that these 2 individuals suffered and their protected ground, there's a number of different things that we want to think about. So one thing that we found at NIJC is really critical to establishing nexus in the context of a gang or cartel claim is to place the harm into the broader context of a norm, of a policy, of the MO of the cartel or the gang. Because frequently the response from the adjudicator or the response from the government side is that this is just generalized violence. The gangs target everybody in the country, and if you disobey the gang, then they're going to target you even more severely. This is not on account of a protected ground. And so you really need to spend time and effort into developing evidence to show that this isn't simply generalized violence. This is part of the way the gang operates, and it's a very specific policy that the gangs utilize to maintain their power and their territorial control. In the Seventh Circuit, we have some good case law that gets to that point, that is showing that a reason for harm, that a type of harm is because of a policy or cultural norm, that is sufficient to establish nexus. In the case of RRD v. Holder, which was a case involving a former Mexican police officer, the Seventh Circuit held that the fact that the Mexican cartels have this policy for law enforcement of you must either be corrupt and be bribed by us or we will kill you, that was enough to show that when the cartel went after him for refusing to be bribed, that was on account of the fact that he was an honest police officer, that it was a policy that the cartel utilized in order to maintain their control over law enforcement. In the case of Sarhan, this involved a woman from Jordan who was fleeing honor killing by a family member, in which the immigration judge had initially said that this was not on account of a protected ground, but rather it was the result of a personal dispute between her family member and her. And the Seventh Circuit disagreed and said, there is a cultural norm in Jordan that makes honor killing in this situation acceptable and in some cases required, and she is being targeted because of that cultural norm. There's no personal dispute between them. This is happening because her family member believes he is required to do this to her. So paying attention to those norms, those policies can be really, really critical. When looking at the comment in matter of AB that the persecutor must be aware of your client's social group, I think this can be very difficult, particularly because the development of particular social group case law has resulted in forcing us in some cases to develop social groups that feel a bit artificial. And I think that's important to always keep in mind that you don't want an artificial sounding social group, and we have other materials you can look at regarding social group case law more broadly, but you need to try to demonstrate that the persecutor was aware of your client's social group or at least those immutable characteristics. And so in this context of a gang claim or a gang recruitment claim or a gang extortion claim, looking at the fact that if you're claiming that your client, the shopkeeper here, Mari Cruz, if she was being targeted because she was a shopkeeper, because she wouldn't pay the tax, you want to be able to get that fact out from your client regarding the persecutor's knowledge of that. So that may include, did the gang member ever say, all shopkeepers have to pay me this tax, you have to pay this because you have a store, or you can't disobey me, you have to pay the extortion. You want to get that information out from your clients to prove that the gang knew that she had that characteristic that was causing them to want to harm her. We usually really recommend avoiding words like revenge, vendetta, and retribution, and this is because this tends to feed into the belief by the adjudicator that this is simply a personal dispute between two parties, right? So those words tend to create the idea of, a personal problem between two people. And we want to make it into something broader than that. We want to show that, again, this is part of a policy, this is part of a norm, it's not simply a vendetta. So avoid using words like that. Be really careful and cautious in your word choice in your brief, in the words you're using in your client's affidavit, and as you're prepping your client to testify in court. And then finally, and this is particularly in the context of gang recruitment cases, but I think all gang cases as a whole, it can be really important to separate the initial reason for targeting from the subsequent reasons for harm. So for example, it's very common for a young man to be targeted for forced recruitment because of where he lives, because maybe his parents are in the United States, so he doesn't have parents around him, because he's viewed as having money because he has parents in the United States, or because of where he goes to school, very superficial reasons in some cases like that. But then typically what happens is once the individual says, no, I will not join you, or does not comply in the way that the gang demands and requires, then the harm typically increases, and the harm may be for a very specific reason at that point. So you may be able to find, for example, strong country condition evidence and expert affidavits stating that the gang's response to disobedience and perceived disrespect in very specific ways. And so saying no, saying I'm not going to join you, refusing to obey, may be seen as a sign of disobedience and disrespect, and that is going to give rise to the subsequent targeting. So it can be difficult in many cases to connect the initial reason for targeting to a protected ground, particularly if it's very demographic based. It's not impossible, but it can be challenging. And so we often really recommend looking at that subsequent reason for the harm. No matter why they initially chose you for recruitment, when you said no, when you refused to comply, how did they respond and what was the reason for that response? So generally at NIJC, when we are putting together our asylum briefing and looking at what documents we're going to have in our index and even looking at our clients' affidavits, when we're getting to the Nexus element, we really try to focus on this three-part analysis. And I think this is particularly important in social group-based claims, but it applies to all types of claims as well. So the first is what Debbie and Sabi talked about earlier, which is the direct evidence. Direct evidence is always going to be the best thing you can have to establish nexus in your case. If your persecutor says specific things to your client that explain why he or she was being targeted, that's great. It's not very common, but it happens sometimes, right? And so, for example, at NIJC, we did an intake recently with an individual who was being targeted because his family was very anti-government. And the police came into the shop that his family owned and said, if you don't stop speaking against the government, we're going to kill you. That's obviously amazing evidence as nexus. You don't get that all the time, and you especially aren't always going to get that in claims involving non-state actors or claims that don't involve a political opinion. But you want to look to those direct words or actions. The second type of evidence is the circumstantial evidence. And this can be, as was discussed earlier, this could be similarly situated individuals. So do you have any other proof of other shopkeepers who are being targeted for harm? And that could be evidence that comes from your client's own experience, or that could be evidence from country condition evidence. Again, really wanting to focus on the targeting of somebody because it's a policy, a norm, it's the MO of the persecutor, trying to get that evidence out. And then context can be really important too. So for example, if the gang threatens your client and says, you have 2 more chances, and if you don't comply, I'm going to kill somebody in your family, and then they do, somebody in the family is killed and it's not clear who killed them, that context, that circumstantial evidence to say, I got these threats and then somebody was killed, and even though we don't know the perpetrator, it's clear that it came after these threats. That's really important, and the case law says that adjudicators have to consider that. And then finally, and I think this one sometimes is not considered quite as much, but the fact that there's country condition evidence showing that the government is essentially allowing this kind of persecution to occur and has deemed it permissible. So again, this is what happened in the Sarhan case I mentioned earlier, and I think the language here is really, really useful to be used in different contexts. basically in Sarhan, the Seventh Circuit said that this woman is being targeted with honor killing because the government has allowed it to occur with impunity and has therefore shown that it is permissible and in some cases required. And so, you can look at evidence showing that there are high rates of a particular type of violence against a particular group, and there is complete impunity for it. The government is not doing anything about it. That can be evidence that it is okay. That helps you show evidence of a norm in that country that that type of violence is allowed, which you can then use to say that this is why the persecutor, this is why the gang harmed my client, because gangs are allowed to extort people with impunity. That's just what they're allowed to do. It's how they are allowed to operate, and that is evidence as to why it occurred. So very specifically then, looking back towards the two examples that we had here at the beginning. So again, we have Christian, who is being forcibly recruited by MS, and we had Mari Cruz, who is being extorted and then threatened for not being able to pay the extortion fee. So what are the type of evidence that we might want to look at getting? So direct evidence is first, right? So we want to look at what are the specific statements, what are the specific actions we can use to show why they were being targeted. So the affidavits are going to be critical. And in any case, any asylum case you have, your client's affidavit is always going to be the most important piece of evidence for establishing the claim as a whole. And that goes for the nexus element as well. Affidavits from other witnesses can be very critical too. So for example, in Mari Cruz's case, when she's having to pay the tax and then she's being threatened and then she closes her store, getting witnesses who can say, yes, I saw the gang go to her store even after it was closed. I saw them threaten her. Or in Christian's case, after he was beaten up, he went home and told his mother what happened, and his mother is able to say, this is what Christopher told me happened. That can be useful evidence to establish the nexus between the persecution and the protected ground. If you can have them, police reports, of course, can be quite useful, although they can be very difficult to get. But you also want to look at all of the evidence you can prove to establish that nexus, right? So in Mari Cruz's case, if you are making a claim that one of the reasons she was targeted was because she was a store owner, you need to prove she was a store owner or show why you can't prove that fact. So you want to provide some sort of evidence that she owned her store, even if it's just affidavits of witnesses who can say that, or if there's pictures or some other proof that she owned that store. The same that goes for the extortion payments. Typically the gangs are not providing receipts in response to an extortion payment that may be made, so you need to think of some way to prove that your client was actually making these extortion payments, if that's what happened. And then you're looking at the circumstantial evidence. So here again, affidavits are really useful from similarly situated individuals. So if you want to show that the gang has a policy of targeting store owners in particular to extort them, and then if they don't pay, they harm them and their families in order to reinforce their authority to target other store owners, then having an affidavit from another store owner who was targeted or who knew of a store owner that was targeted can be really crucial. And the same in Christian's case. So if another one of Christian's friends was also being forcibly recruited, or there's a family member whose son was being forcibly recruited and who was then harmed for refusing to join the gang, that could be useful circumstantial evidence. And again, just keeping in mind, you want to show that policy response, that social norm, that modus operandi of the persecutor. There's some really great country condition evidence that you can get talking about this in both the recruitment and extortion context. There's a report from the International Crisis Group, for example, that has really great information about how the gangs in particular utilize extortion as a really critical part of their operations. It's how they expand their territorial power and control, and it really walks through what groups are specifically targeted for extortion, how prevalent the extortion is, and how critical it is to the financial well-being for the gang. So really look into that evidence and use that evidence to pull your case out of the generalized violence category. And then finally, you want to look towards other country condition evidence, right? So you want to look for the fact that gangs know they can forcibly recruit and target people for extortion with impunity because the government allows it to occur. You want to look for evidence as to you know, how frequently this happens, the typical responses, the fact that the gangs respond in a particular way when they are disrespected or they're perceived as being disrespected or being disobeyed. So look at these three categories and see how you can gather that evidence to really develop the nexus element in your case. And now I'm going to turn it over to Harvard for the next example.
Hi, I'm John Wilshire. I work with the clinic. Carrera. And so what I'm going to do is I'm going to talk a little bit about Maria, who, it's a made-up name. She's actually a client of mine who presented her case last year. And so I'm going to walk through it because I think for us, it's always very important to sort of build the cases from the ground up. And so what we try to do is basically following, you know, and trying to implement all the different things that have been said so far on this training. I'm going to walk through things and explain how this case evolved. So at the very beginning, Maria came into our office and she had a hard time talking about what had happened in the past, but eventually she ended up being clear about one thing, which is that she had fled Guatemala because her husband had become very abusive. So based on the fact that she is indigenous, she's from Guatemala, and she had a domestic violence case, we wanted to go forward on it. We also represent a number of people in their community, so that was one of the reasons as well. But we decided to go forward. So we then did an intake, and what you see on the screen is really what we ended up picking up on the intake with her. And so from the intake, it was very clear that she was targeted as she was from a Mayan family, and that they had been targeted during the Civil War. So right away, that raised a lot of issues for us. And so we knew from experience from doing this work that a lot of people in these communities and these Mayan communities from the area that she was from which she came, had suffered a lot of harm in the past. And this is actually the Department of Quiché. So we figured at the very least we'd have race there and possibly real and imputed political opinion, because at the time, when the war took place, a lot of these families were targeted for those reasons. The fact that she said she went to school and she was called an India at school made it clear to us that there was something going on at school that obviously had to do with her race, and that probably was a very important part of her claim. But at the very least, it was something that and so we realized that was an important piece that we need to work on as well. And then finally, we got to the point where it was clear that the man who was attacking her husband, was Pablo, and that the abuse was there, and as she said, he became more and more abusive. So clearly, the harm it appears as if, given the fact that she was presenting, that she was seen very traumatized, etc., that there was a lot of harm there. So we decided to go forward. When we actually ended up working through the claim, we ended up figuring out the following and presenting the following, which I think evidences the fact that this is what she presented as a simple, not a simple, but a basic domestic violence claim turned into much more than what we thought at the beginning. And so what we ended up realizing is that as we worked with her, we interviewed her extensively, we also talked to people around her, her family, etc. It became very clear that her family was from the area of Quiché, from a town called Sacualpa, which was particularly targeted by the Ladino Guatemalan government during the Civil War. And if you look at the documentation, a lot of corroborating documentation on this issue, that is country conditions documentation, evidences that in fact when this government, and actually there's great First Circuit case law on this, that when the government attacked these areas, what they claimed was that they were attacking them because they were going after the guerrilla fighters, when in fact the attacks were really focused on these particular communities because they were indigenous and they were standing up to the army, and the Guatemalan government and the Ladinos who were controlling the area were very much threatened and wanted to do away, particularly with the communities and the families that were problematic. So we ended up spending some time trying to figure out exactly who her family was, what they had done, and we ended up realizing that her father and a number of family members had been very much involved in protecting their communities during the war. And as a result of that they were targeted by not only the civil commanders in the area who were charge of sort of focusing the attacks by the government, but also by numerous other landowners, Ladino landowners who were after their property. And so as a result of that, the family became very targeted, and as they stood up, they became more targeted. And then we ended up realizing that, in fact, as a result of that after the Civil War ended, in fact, they continued to be targeted. And she herself had learned in politics from her parents and her community, and she herself got targeted further down as she got older, particularly as she stood up. So that became a very important part of her claim. And it was clear that at that point, as we heard the claims, we ended up realizing that as a child, she remembers very well that her parents were targeted. She was there. The soldiers would come by. The parents would grab her and her family and run to the mountains, and they'd spend a lot of time there. She witnessed the targeting. She witnessed the effects on her parents. She also witnessed the kidnapping of her father at one point, and she knew that a number of family members had died. Even though she was a child at the time, she remembers how it felt, and she learned about it as she grew up. And the community was constantly, particularly Latinos, were constantly calling them indios, and were calling her parents communists and guerrilleros, which is guerrilla fighters. So there clearly was a claim based on that. So we realized that there, as a result of that, she had a past persecution claim based on her race and real and imputed political opinion. And clearly she came from a targeted indigenous family, and so the harm that she had faced then was also had family membership as a nexus. We then also spent a lot of time trying to figure out what happened with her at school, and we had learned from experience that the relationships at school are very important for these communities, because at the very least it evidences the very basic nature of racism in these communities and the way that these families are mistreated, and it's ongoing racism, and it's actually very overwhelming. So we spent a lot of time talking to her about that. We ended up asking her about her relationships with her teachers. Who were they? She was very clear that they were Latinos, and Latinos in this particular case are the mixed race people who are either white or who have white blood in them, who don't see themselves as indigenous, who see themselves as basically they're the people who come into the area to colonialize the area, and that's the relationship that's there. So as a result of this work, we ended up realizing that the teachers were Latinos, and then as we talked it through with her, we ended up realizing that, or we ended up hearing that she had suffered extensively, but she'd suffered extensive humiliation based on the fact that the teachers treated her basically and the other indigenous students as servants. And so they were actually training them to be servants for the Latinos, and there were a number of Ladino kids in the class, and it was clear that they were getting treated very differently. These kids, including our client, was, for example, made to pick up the trash, wash the floors, clean the toilets, go out and do errands for the teachers, while the other Ladino students they were allowed to do their classwork. And during that mistreatment, a number of times when the teachers would get mad at our client and other indigenous kids, they called them indios pendejos. They would say to them, basically, why are you here? You should be out working. You're wasting our time. And she was really made to feel that she couldn't speak her language and she should be ashamed of her family. A number of times the teachers made comments about her parents and her family as being troublemakers, as being indios guerrilleros. So that obviously went through it as well. So we have direct evidence of racial animus there, and clearly the mistreatment on her part, the harm was very high. When we asked her about her relationship with the Ladino students, she explained that in fact the Ladino students made up probably half the class, and that as far as the way she felt is that Ladino students had been taught to be very racist by their parents, and the teachers really condoned it, and so the Ladino students treated them very badly. They too called them many names. They made references to them as being animals and saying, why are they there? And so there's a lot of mistreatment there. So that was another chunk of the case that also raised past persecution. It was another part of the past persecution case that we presented, in which it was very clear that race was an issue, and that in reality, until particularly in the primary schools, maybe there was imputed political opinion because they were saying these things about their parents. But as she got older and she stood up to these other kids and to the teachers, it clearly became, particularly when she would stand up to them, she would be more abused and more punished. That was clear that it was also on account of her political opinion, thinking that she as a child, as an indigenous kid, as a person had a right to be treated as a human being, and they were mistreating her. So that became another big part of the case. And then we went forward and we ended up realizing that, okay, so she continues on to school, which is, you know, which in itself was a lot of the clients that we have end up having to drop out or dropping out over a period of time because they're so badly mistreated, and also there's a real need for the families for them to try to be of help to them if they can. But in her particular case, her parents had a little bit of more resources where she was able to go on, and she was somebody who really believed in being an independent girl, an independent woman, so she wanted to study and go forward and be like, and help her family like her brothers. And so that was a big part of the case as well. So that you start developing the understanding that she, as an individual, is standing up for herself, and a lot of times she's being targeted because of her political opinion. But as she goes up, she also becomes politically active, like her parents, in the indigenous community, for which she is being targeted. She was targeted by a local mayor who was who was actually indigenous, but it was somebody who had supported the Ladinos during the war, and he was somebody who was very controversial, and the parents had organized against him, and she actually got politically involved as a young woman, organizing against him as well. She was organizing other girls to participate in elections, and she got targeted for that shortly before she left. So again, there was another piece to the claim that involved political opinion, her own political opinion for standing up for indigenous rights and her and rights and the rights of young women in the area. And then we got to the claim that we originally started with, which was the domestic violence claim. And so one thing that became very clear was that the man who was her husband, she saw as her husband. Now, she wasn't actually married to him, but she lived with him. And it was very clear to her, and it's well documented, that within her communities, if you live with a man and it's a domestic relationship, people view you as the man's wife, and you're seen as being married to within a married relationship. And so in this particular case, Pablo was a Ladino. And so she had gotten involved with Pablo in the beginning because of, as with all these relationships, I think in the beginning things have a lot of possibilities and men behave differently. But then when she started living with him, he became increasingly jealous and started really trying to control her. And she was very clear about that because she wanted to continue with her studies. And he was very, very increasingly, I think, concerned about her doing things that wives should not be done. His wife should not be doing this. He kept on saying that she was his woman, she had to follow his orders, and his wife should not be doing this. And then when she would really stand up to him, he would start yelling at her that she was an India puta, which means an Indian whore, a cualquiera, prostitute. And so he really started coming down on her for standing up to him. And as time went on, he became increasingly more abusive physically. He started beating her, and then eventually, when he wasn't able to control her, he started raping her. And that's when she decided she could not. She was afraid that at some point he was going to kill her, and her parents helped her escape to the United States. So then we had the other part of the claim, the final part of the claim, which is that she was in a relationship. Domestic relationship she couldn't leave, but in this particular case, I think now I would really emphasize the fact that he viewed her as his property, and he treated her in that fashion, and the more she stood up to him, the more he started targeting her because of her political opinions in terms of standing up for her own rights as a woman, as an indigenous person, and as the relationship went on, he became increasingly abusive on her as to her race in terms of being an indigenous woman. That became more and more of an issue. And with time, he started threatening her that he was going to turn to his friends to put her in his place if she didn't listen to him. And it turns out that his friends, that he had very close connections because of who he was in the community, because his Ladino family had some power, that he had connections with the police, and he also had connections with Ladino gangs. And so that became another major issue in the claim. Okay. So what happened is we started, I think, with a domestic violence claim that seemed like it definitely could fly in this court, because the judges in this area and in this court have become much more aware of these claims. And with ARCG, they present these claims, and you didn't have to really focus on providing evidence on everything. But we said, okay, we'll start there. It clearly is one of these cases. By the time we finished it was a much more nuanced case with multiple grounds, and so when we presented it to the judge, at the end of the day, the judge was very clear that he understood the claim, and he understood it as being much broader than the domestic violence claim. And the fact that she was targeted as a girl, and that she suffered ongoing racism at school was hugely important to this claim. And the fact that she's somebody, at the end of the day, who, when she came to the United States, she continued to get threats by her partner, her husband, who was back there. He would try to call her, he would threaten her, he would tell her that she's his woman, she's got to go back, that's her place, and she's going to, and when she sees her next, he's going to make her pay for this. All went to that. Okay, so how do we pull all this together? Well, going back to what Ashley was saying, what we did is we definitely focused on direct evidence of the harm that she suffered. But first of all, that she suffered being a member of her own particular family that was targeted during the war. And it was very clear that there were a number of times when the Latinos were very clear about the fact that they were attacking her family. And later, as she grew older, her on account of her race, by calling her an India and referring to her in many different humiliating ways based on her race. It was also very clear that the husband, okay, so in school it was very clear that, as I mentioned earlier, that the race issue is that there's a lot of direct evidence of mistreatment on account of her race, and as well as on account of her real and political opinion. And as she got involved with the relationship with Pablo, he increasingly became much more offensive and threatening, calling her many different names based on her race and her gender as well. So that was there, and we submitted, basically we provided all that evidence through her affidavit, which her affidavit was a very detailed affidavit, but also her testimony in court addressed all these issues, and she provided a very, very strong testimony in court when allowed to talk about these things. That in the beginning she had a hard time telling us, because we all look like the people who attacked him in their village, I believe, especially me, because I'm Latino, and so it took time for her to be able to open up. But by the time we got to court, she was very, very strong on these issues and provided very good testimony on these specific issues. We got affidavits from friends and family, and from family members, from her parents corroborating the claim, from siblings corroborating the claim, and so that corroborates and they corroborated the fact that they were all called these names, and all the direct evidence, but also the fact of the targeting as well. We also got her to testify at her, or in terms of her testimony in court, and also in her affidavit, to talk about what had happened to similarly situated women in the targeting that they had received as children in school and through their relationships. So that was a very important piece. We also we provided extensive testimony talking about what had happened in Guatemala during the Civil War, what is going on now, the remilitarization of the struggle since 2012 with the indigenous communities, between the Latino government and indigenous communities. All these issues were very well documented, and so it was very well corroborated in that sense. We also made a real point of providing evidence, basically evidence that, expert evidence that dealt with issues of machismo as she described machismo in Guatemala, and that was an important point, and the sort of the culture of machismo, and the culture and the way domestic violence plays into the culture of machismo in Guatemala, in her own community. Now, in this particular case, she's somebody who was married to a Latino, so that added obviously the racial component to it. But obviously, as you do these cases, you end up realizing that a lot of the mistreatment of the machismo also comes from indigenous men, and so this expert testimony played a key role in explaining all those issues. and making it clear that it wasn't just something where he, this man was doing this to her because he was jealous and it was just simply his personal opinion. This is something that is created, or these environments are created based on, unfortunately, on cultural reasons and on the attacks on these community, and this evidence explained those things really well, and that was very important. And then at the end of the day, given all the harm that she had suffered, when she first came to us, as I explained in the beginning, she was suffering. You could tell that she was very traumatized. So we had her evaluated, and we had very strong testimony involving addressing the issue of PTSD and trauma at this point that our client was suffering, and talking about basically what are the symptoms and and how that corroborates her claim. And so that was how that claim was presented. And as I said earlier, this was something that at the end of the day, the judge understood it really well and granted it without any problems. Now, things are different now in the sense that I think the judges are still there. The law hasn't changed, but we do have new judges that are being brought in to bring some cases, and obviously, AB is going to have an effect. So I think as we put this case on, we probably would do some changes, make some changes, and put in some new evidence addressing the different elements of the claim more specifically. But I do believe this claim shows that, in fact, when somebody comes in with a simple claim, there usually is a lot more to it. All right, Ashley.
Yeah, so I think, that's such a good example because it shows a number of things that we see as being so critical to the preparation of an asylum case. And I think one of them is the importance of spending a lot of time with your client before you even get to the point of deciding what are my claims, how am I going to present them, how am I going to brief the case. We always say that, spending that time with your client and doing that affidavit preparation is the most important part of your case. You need to start it early, because as John indicated, stuff is going to come out slowly at times. You have to, develop a lot of trust with your client. And I think particularly for the Central American population that we're frequently seeing nowadays with these types of claims, there usually is a lot more there, as John said. And so it's really important to spend that time, because some of the things that your client may have suffered in the past that could be a basis for an asylum claim, either your client's not going to discuss them right away because your client has normalized them as something that's common and not a basis for protection, or they're not what caused your client to flee ultimately, and so your client doesn't think that they are important to raise with you. And so it is very, very common when we are speaking with clients, especially women, that they may present with, this is why I came here, this is why I need protection, but as we spend more and more time talking to them, we learn that they experienced prior physical or sexual violence in their family, with others in their community, that they did not tell us either because they were not comfortable sharing that initially, or they didn't think it was important. And in almost every case, you want to bring all of those past experiences into the claim that you're presenting to the judge, even if you don't think it's ultimately going to win the day. We had a case very recently in which the judge granted asylum, where the client at the very last minute told her attorneys that growing up, her stepfather had been abusive towards her mother and her family, and she had not raised that earlier because it wasn't why she came here. She hadn't been living with her stepfather anymore at the time she fled to the United States, and she had a complex relationship with him, and she didn't want to say anything bad about him. But the fact that she had experienced gender violence at a younger age, the fact that her mother had experienced violence, is, if nothing else, really critical context to explain that this is something that occurs frequently. This is something that nobody intervenes to stop. And so the attorneys in that case were able to submit a supplemental affidavit that addressed that fact, and I think that was a really important addition to the case. At the end of the day, especially now after matter of AB, you don't know what is going to be the particular claim that the judge is going to want to hang his or her hat on, right? And if you have a client with very compelling facts, often the judge is going to want to find a way to grant asylum, but the judge wants to do so typically in the safest way, in the way that's not going to lead to an appeal. And so the claim that you think is the strongest claim may not be ultimately the one that the judge decides to grant on. And so you want to give many options to your judge, many ways that the judge can grant asylum, many different types of claims, different groups. and really you want to present all of the past harm in your client's case that could give rise to an asylum claim, even if it wasn't what ultimately caused your client to flee. So the next claim we want to talk about is gender nonconformity. And these types of claims, I think that the theories behind how attorneys should present these claims, I think, are still being developed, and I think different attorneys will present these claims in different ways. But this particular case involved an individual who has known that he was gay from a very young age. He's from a Central American country. Growing up, his family members often taunted him with homophobic slurs. His teacher would punish him for having effeminate mannerisms, and then in response to that, his father would physically abuse him. As he grew older, he also was regularly threatened by gang members, similarly to others in his community, other young men in his community as well, except the threats to him often specifically related to his sexual orientation or how they perceived his sexual orientation, because he was not out in his community. They would include threats of sexual violence. He went off to university and was in a relationship with a man, but then when others found out about it in his professional community, he was ostracized, he was fired by his employer, and he ultimately felt that he was not able to be freely out in his community, and he felt that that was affecting him severely, and he did not want to live in that environment anymore, and he fled to the United States. So sometimes these claims will be presented as, a social group of somebody, a gay man from El Salvador, for example, might be the particular social group. More often than not, we are now presenting these claims more along the lines of gender nonconformity, as opposed to a specific sexual orientation, or as opposed to being transgender, having a particular gender identity, with the idea being that it's not so much specifically that you are gay or a lesbian or transgender, it's the fact that you are not conforming to gender norms, and that is what is giving rise to the persecution, that is what is giving rise to the asylum claim. So again here, especially when you're looking at the gang violence that he suffered, the threats of gang violence, you really want to make sure, like with the other gang claims, to differentiate the harm against your client from general violence. And then with the family violence, you also want to specifically focus on the harm inflicted and the words used. So very frequently, we'll see judges who will say, well, your client was not out to anybody. Nobody knew his sexual orientation. So you don't have any proof that they were harming him on account of his sexual orientation. Or they might say, well, the father abused, he beat other children in the family. That doesn't mean that he targeted your client because he was perceived as gay or because he was perceived as gender nonconforming. Now, of course, there may be a separate family violence-based, a family-based social group for that family violence separate from that. But it's important to really be able to explain in your client's words, and then possibly with evidence from others, as to why your client believes that it was that gender nonconformity that was giving rise to the persecution. So that may involve looking at words that your client's father and uncle used when threatening your client, when harming him. That may involve context. So in the case of the school incident, being able to tie the fact that the father knew that the teacher in school was beating him or was punishing him because he was acting like a girl, and then in response to that, the father beat your client. So just making sure to really draw those connections, which may seem very obvious, but it's important to really develop that strong record, because again, in this post-AB era, it's much more difficult to predict how judges are going to rule. It may be that we are seeing many more appeals in the future, and the most important thing in preparing for an appeal is that you have a strong record below, because of course, you can't typically add new evidence up on appeal. You can't typically dramatically change your legal arguments. You're stuck with what happened below. So you need to have that strong record. You need to make very explicit those connections with the nexus between the persecution and your client's protected ground. Similar to the other gang claims, avoiding those words like revenge and vendetta and retribution, and then really utilizing country condition documents to demonstrate attitudes and norms and legal standards. Unfortunately, in gender identity, in sexual orientation, and gender nonconforming based claims, there are often some really good country condition documents from Central America to help establish, the norms And again, specifically that idea of gender nonconformity and the norms and attitudes towards people who are not conforming to how a man is supposed to act, for example. So we're again going to look at this three-part nexus analysis. So, the direct evidence and words that I have talked about already. I think, in every single encounter that your client had here, anytime that he was being discriminated against, anytime he was being threatened, anytime he felt unsafe, you want to get out the words and actions that were used. But again, you also, in this type of claim, you want to look beyond that, because part of your client's claim is that he could not be out in his community as a gay man, and that in and of itself constitutes persecution, right? And so to get out that, you want to look even more broadly than the specific actions and words that were directed towards your client, and look towards actions and words more broadly. So growing up, did he hear anything from his family members? Did they say anything about their attitudes towards gay men, for example? Did they say anything about how a man is supposed to act, how a woman is supposed to act? Did he hear that in his community? Did he hear that in his religious community if he went to church? When he went off to school, did he hear people talking about those sorts of things? That's going to impact your client's perception and safety as to whether he could be out in his community. And so you want to get out that is also direct evidence, even though it's not direct words or actions that were made specifically towards your client. The same goes towards the circumstantial evidence, similarly situated individuals, laws, although you have to be careful about laws, because often we'll see in gender nonconforming or sexual orientation-based claims, there may be laws on the books that seem quite positive, and they may say, that there may be laws allowing same-sex marriage, or adoption by same-sex couples, or there may even be, certain hate crimes related legislation on the books. But you need to look at what is actually happening on the ground. And in some cases, you may see situations where on the ground, the community norms, the social norms are such that when those laws actually came into place, it caused more harm towards people who identify as gay or lesbian, as transgender, in response to those laws. So the fact that those laws exist can sometimes make situations more dangerous on the ground for individuals, notwithstanding the fact that those laws are on the books. Another particularly important type of circumstantial evidence, I think especially in the context of sexual violence, is looking at the type of harm inflicted. In the matter of Kasinga case that was talked about earlier, there is language that says, in the context of female genital mutilation, we don't have to look too far to understand why the FGM is inflicted, because FGM by itself is meant to control women, control, in theory, the sexual desires of women and things like that. And so you don't have to look too far to understand why it's inflicted. It's inherent in the act itself. And so we will often make those same arguments in the context of sexual violence and domestic violence and, gender and based violence by saying that, acts of rape are intended as acts of power and control. And so you don't have to really look too far to understand why a rape was inflicted. It's inherent in the act itself. And, when you have, for example, in this type of case, a gang member threatening to rape an individual who is perceived as gay or is out as gay, you can assert that that very act of rape itself is intended to demonstrate, masculine authority over this individual, right? And so that is in itself an act of persecution on account of an individual's sexual orientation or gender nonconforming status. And then beyond that, again, looking back at that Sarhan case. So I think, again, when you're looking at these claims involving personal violence like this, or violence within a family, violence within a relationship, looking to those social norms, looking to see what country conditions implicitly allow, and using that to argue that this is not, that the father was not abusing him just because of that father-son relationship. It was because it's deemed permissible to treat your sons this way if they are not, quote unquote, acting like a man. And so using that evidence to show the nexus in your case between the persecution and the particular social group. So again, looking at the chart here in terms of direct evidence, circumstantial evidence, and other country condition evidence, we kind of keep following the same line. And if it seems repetitive, it's somewhat repetitive for a reason. This is how you want to present your claim. This is how you want to put your case together. When you're talking to your client and putting that evidence in the affidavit, you want to be thinking in terms of these three categories. When you're putting together your index of supporting documents, you want to be thinking about these three categories. And then when you're putting together your brief, typically in the briefs that I do for asylum cases, I break my Nexus section down into, part A is direct evidence, part B is circumstantial evidence, part B is other country condition evidence, and really look to present your case that way. So we've talked about most of this already, but again, just thinking very broadly, keeping in mind that the standard for corroborating evidence in asylum cases is quite high. And although your client's credible testimony alone could be sufficient to meet his or her burden of proof, if the adjudicator wants corroborating evidence, you have to provide it or show that it's not reasonably obtainable. And so you really want to think broadly. In Miguel's case here, you want to look to be really corroborating all aspects of the nexus to the various forms of harm he suffered, right? So you want to be corroborating the harm that he suffered from his father and uncle, and so that may be affidavits from other family members who witnessed that, if he has relationships with those family members anymore. If he doesn't, if he's completely estranged from his family, then he can explain that in his affidavit and explain that he is not able to get evidence from anybody else. He's not able to get statements from anyone in his family because nobody in his family talks to him anymore, and that's okay as well. For any of these situations, if you ever made a police report, when he was fired from his job, you want to get proof that he had that job and then hopefully proof that he was fired. All of those situations. Country condition evidence, again, here, I think, as we talked about earlier, getting a country condition expert can be really useful. In these types of cases, in gender nonconforming cases, there is often extensive country condition evidence you can find, which is great. And so that may sort of minimize the need for a country expert, but it's going to be a case-by-case and a country-by-country determination. So keep that in mind. And then, again, when you're looking at whether there's any laws on the books regarding, for example, same-sex relationships, you want to make sure to compare and contrast that to what is actually happening on the ground. And that's where an expert can be really useful, because often if the situation on the ground is very different from what the legal situation says, then you are going to need to rely on an expert who can differentiate that situation for your adjudicator. All right, so we're gonna, I think, go through one last hypothetical here since we have some time to do so. This kind of continues with some of the other facts and evidence that we talked about earlier, and then we'll have a little time for questions if others want to add questions at the end.
Okay. So this is another case involving an indigenous person who's a kid in this case, and he presented a case when he first came of somebody who fled Guatemala because he was being targeted by gangs. And so as we worked on the case, we ended up coming basically with this set of facts that's been presented here. And so it's very clear that, again, it's one of these situations where he comes from a targeted Mayan family, and so we figured that there was a lot of history there, given the fact that he appeared to be saying, and we knew some of the family members of his family members here, that they were people who were active in the community during the war. However, he had been born after the war, so we're trying to figure that out, but we thought that was an important piece. Clearly, he also said here that he was mistreated in school. So again, as I mentioned earlier, it's the same type of situation in schools. That was an important point. And third of all, he presents again this fact that he's been targeted by the gangs as he's going and coming from school. And so we spent a lot of time dealing with him as well, and we ended up realizing again, as in the past case that I presented, that in fact he came from a family that grew up during came from an area where the government is known and is for having committed genocidal attacks. And so his family was very, very targeted, but he grew up afterwards. And so it was, I mean, although the history of the family is very important in trying to figure out what his case is, the harm that he suffered was different because, in fact, he grew up at a later time. But as we worked through the case, we ended up realizing that he grew up a very affected family. A lot of people have been killed, and a number of family members have been forced to flee the country as a result of it. So there was a lot of harm there, and it was based on his race clearly, and as well as on the imputed and real political opinions of the family. So here we have family, social group, and race clearly on the table. So this is part of the case that we ended up presenting, and that was a big part of the case because there was a lot to it in the sense that he comes from a very political family. Then the mistreatment in the school is basically the same mistreatment that I talked about earlier, and in his particular case, he also was targeted. He comes from a village, so it's different from if you live in the towns and the municipalities where there are more Latinos than in the villages where there are less Latinos, but still the Latinos in his village were people who had targeted his family and who had a lot of power. So that again was the same set of issues. He was mistreated by the teachers basically in the same way, using the same language, forced to do the demeaning things at school. And the other Latino kids also went after him the same way, and also because of his family. So again, in that particular situation, clearly the race, political opinion, and family membership were key elements of claim in terms of grounds. What was interesting in this particular case, and this is why I wanted to put forward, is that in fact he had originally said he was targeted by Maderos, and that they had tried to kill him, and that's why he had left. But he'd also said that in fact he had been targeted because when they targeted him, they told him to stop participating in the church in community groups, and so that's what made this case more interesting or different in that sense. It put another spin on it, and as we worked it through, we ended up realizing that what had happened was that his family had been very targeted. They fought during the war and they defended their communities. But as time went on, what ended up happening is that they ended up organizing, putting a lot of their emphasis on their organizing to save their kids from the attacks by the Latinos, and it was coming in two forms. One was that the people who were working with the gangs, the people who were organizing the gangs, were very connected to the people who had been organizing the civil patrols in those areas. And so there was an evolution where before the civil patrols were clearly connected to the army. With time, as the conflict got demilitarized after the peace agreements, the army was pulled out of it, so the civil patrols were sitting there, and the people who were running the civil patrols during the war had a lot of power. But with time, as they all got older and all that, they started losing their power. But then there was a time in 2000, starting in 2012, there was a president got elected by the name of Otto Perez Molina, who is somebody who had been one of the top commanders during the Civil War. And he was a Latino who was very racist, and he, as part of his rhetoric of running for office, he promised that he was basically going to come down with a mano duro, with a hard hand against everybody, all the factions within the communities that were using violence against communities. So in this particular case, I guess the notion is that he was going to stop troublemakers. And the people in these communities knew very well, given who he was, and the way the rhetoric was going, that in fact what he intended to do was come down hard on these communities again, because over time they had been organizing. There'd been a lot of movements within these communities that had given them more space and more resources, and so they saw this as a way of putting them back in their place. And so one of the things that comes out of this is that when the armies come back into, when the things are remilitarized, particularly after 2012, the armies come back in, and the soldiers come back in the area. They start remaking their connections with the old civil patrols and their families, and these younger family members are now working with these civil patrols and the army, and they're actually being used to implement the policies of attacks on these communities. And so his family and many other indigenous families, particularly through his church, had spent a lot of time trying to make sure that the children in their communities weren't taken from them. That's what they were seen. They were seen as that during the Civil War, that in fact, while the government was able to use the civil patrols to divide the communities, and hopefully, and their aim was to destroy the power of these communities, they haven't been able to do it in many of these communities. And now one of their tactics was to go in and what they call steal their kids. In that sense, they would either they would come in and they would force kids to either join these Latino groups or or leave. And if they didn't leave, they would kill them. And so that's how the families were organizing to keep their kids from joining these groups. And so the father of this particular, of Jose, was somebody who was very much involved. In fact, he had an aunt who was very much involved. And she had actually gotten brutally assaulted during around 2012. As a result of these things, she ended up later dying. But the father had continued within this church, organizing kids and sort of building their cultural base so that they wouldn't give it up and join the gangs or leave the area. And as a product, and that's one of the reasons, and that's why they were targeting him when they were saying, basically, stop participating in your church and your community groups, because they were the gangs who were seeking to control the area, but also to take control of these indigenous kids. And part of it is that they wanted to use the kids to do their stuff, but a lot of it had to do with control and finding a way of destroying the indigenous community and pulling the kids out of them. So that's what that statement was about. So this particular Jose basically was 16 when he was between 14 and 16 when he was targeted. And so when the gangs came in, they did not demand money from him. What they demanded was that he stop participating in these community groups and that he joined them. And when he stood up to them, they targeted him. And he was very clear when he stood up to them that, in fact, he didn't believe in their way of life. And so their way of life for the indigenous community means a non-indigenous community way of life, particularly a gang-related way of life, which is based on basically control of an area and basically using everybody within the area to do their work and to further their demands. And they use violence in the process of doing it, which is, these are basically privatized armies in this area, and that's how these kids saw it. So when he stood up to them, they went after him for that. And then later, when they couldn't get Jose to change his mind, they went after his father, and as a result of that, he and his father had to flee, and that's why they were in the United States. So I think this is an important case in the sense that makes it clear that when the gangs go after somebody, there could be more than one reason for it. And in this particular case, it was on account of his political opinion. He was standing up for his indigenous rights and his cultural opinions, and that's why they're going after him. Now, the other thing that we learned from this is that in these areas there are not just Ladino gangs, but there are Ladino bands of young men and sort of middle-aged men that go after all these communities, and that go after these communities, and they target these communities. And so we ended up realizing that what looked like it appeared to be simply being targeted by gangs was really being targeted by Ladinos as a whole. And the gangs were only part of that group that was attacking them. There were these other groups of indigenous folks young men who basically, they're organized. They sort of monitor the town. They think they own the area. They should own the area. And they're constantly going after these indigenous kids, either to harass them and to force them out of there, because a lot of times these families, the Ladino families, are constantly trying to force families out of the area for political reasons, but also because they want to take their lands. And in other cases, it's like bullying, but at a very, very high level of bullying, because a lot of times these kids, when the Ladino gangs come after these kids, they beat them up, they even kill them. So there was so what seemed to be simply being targeted by Ladino gangs, it turned out to be by Ladinos, by gangs and by the young Ladino men who come from these families who had targeted his family and his community for many years. So it was a continuation of the Civil War in a sense when he left. And so this is the case that he presented. And so there were many different grounds there as well. And again, it was one of these situations where, like Ashley's explained, it's presented, we presented it in terms of we talked about the direct evidence that was statements that were made to him, corroborated by family. We also had an affidavit that addressed a number of other similarly situated situations, about what's going on with similarly situated kids in the area. Many of them were actually within his family as well. They had been forced to flee. We had affidavits from corroborating the claim from the family and from folks here who know the community. We put in a lot of evidence, a lot of country conditions concerning, racial mistreatment and the genocide in the 80s and the ongoing mistreatment and the new attacks by this new government that's remilitarized the struggle by folks in the area who have been organizing within the indigenous communities to give support to their communities back at home, and for which they're now being targeted here as well. If they're being told that if they ever go home, they're going to get targeted for that. We also had extensive evidence about, very strong testimony about PTSD and the effects that it had on Jose as he was growing up, and so again, it's one of these cases where it was granted by the judge, and basically the government conceded, and it was it's like Ashley was saying. I think once people see that the person is a real refugee, then they look for ways to grant the case. In this case, the judge was very focused on this treatment that Jose had suffered in school. And that was an important element for us, because it sort of helped build him up as an individual in the judge's eyes, but it also was political opinion and human rights, denial of his basic human rights to an education. So it added many different layers to it. And so again, it's another one of these claims that I think looks simple, and when you start off with, and then becomes much more complicated. And there are many different ways of presenting it in a way that gives it, it brings it to life. Okay. That's it, Ashley.
All right. Well, so that is it for today in terms of our formal presentation. We have some resources listed here. And again, we will have this recorded version of the webinar and the PowerPoint itself available on NIJC's website sometime next week. We will stay on the line for a little bit longer to see if we have any questions. And so we'll be here for a couple minutes, and then we will sign off. Okay, so it's looking like we don't have any questions at this time. I don't think I have anything more to add here. Does anyone from Harvard want to have any final comments?
No, I think we're fine.
Yeah, I think we're fine.
All right. Well, thank you all for listening today. Again, we will have this up on our website soon. And please don't hesitate to reach out to us through the links on this page here if you have any follow-up questions.